Hello, everyone. Welcome to today's webinar from the Wagner Law Group. We're going to talk about the impact of the current economic challenges and downturn on defined contribution plans. This is Steve Wilkes. I'm a partner in our San Francisco office. I work primarily in our investment management law and fiduciary areas of practice. My esteemed colleague, John Schultze from our Boston office, is also on the webinar today, and John leads our employee plan retirement group. So just as a matter of getting started, we're talking about defined contribution plans today, and we're going to talk about some different components of, some of the impacts of the law and changes and things that are going on that one might consider during these really challenging times through the prisms of, plan operations, plan administration, and then I will finish up with a few comments at the end on fiduciary matters. By the way, for those of you that are interested, John and I have also done a webinar on some of these special considerations and concerns that might arise with respect to defined benefit plans. And that webinar and other related materials will be available on our firm's website, and you can go there and find it along with other, COVID-centric and other, general webinars and alerts and what have you. So please look around for some resource material if you're interested. But having said that, welcome again. We hope everyone is feeling, is doing okay, that you're safe and healthy. Thank you for joining us today. And I will turn it over to my colleague, John.
Thank you, Steve. The current volatility in the economy due to the coronavirus pandemic has created various issues for retirement plans that need to be addressed in an expedited and efficient manner. And the impacts are on defined contribution plans, including 401k plans, profit sharing plans, money purchase plans, and 403b plans, which we've categorized into these three broad areas: day-to-day operations, plan administration, and fiduciary matters, each of which has a range of considerations that we'll walk through. Some of the general issues: we want to make a distinction between a suspension of employment and a permanent severance from employment. A furlough, leave of absence, or layoff of a temporary nature generally would not be considered a severance from employment. A permanent layoff or reduction in force generally would be considered a severance from employment. And the distinction largely depends on the intent of the employer. Will the employees be coming back or not? A suspension of employment impacts eligibility to participate and to receive employer contributions and vesting. In elapsed time plans, an employee is credited with periods of service, which generally means the employee must be employed at the beginning and end of a specified period or for a specified period of time. In hours of service plans, an employee generally must be credited with a specified number of hours of service during a measurement period. And hours of service are credited for actual hours for which the employee is paid or entitled to payment, or it's based on Department of Labor hours equivalencies. With respect to contributions, participants can make contributions from compensation they receive. If they're on an unpaid leave, they will not be able to make contributions. An employer's obligation to make contributions is usually based on participants' compensation or the hours they work. So unpaid leave means no contributions from the employer for those periods. Also note, the compensation definition is contained in the plan, and certain payments to employees may or may not be included. For example, an employer with salary continuation payments that are reported on Form W-2 might be able to defer from those amounts, but whether or not compensation includes unusual amounts is a fact-specific issue for which outside counsel might be needed. Note that a suspension of employment generally will not be sufficient to permit a participant to take a distribution from his or her account. Unless there's another basis for accessing the account balance, such as an in-service withdrawal, there's no reason to make a distribution payment. Note also that loans that are paid through payroll cannot be issued if there's no expectation of a repayment. We'll discuss the impact the CARES Act has on these issues shortly. A permanent termination of employment would justify distribution requests from participants to be processed, as long as the plan allows those people to take distributions. Some plans still restrict payments until normal retirement age. Partial plan terminations may occur if one or more of a series of layoffs affects 20% or more of the workforce, in which case terminated participants will have to be made fully vested. We recommend not making an immediate determination because it's possible that in the short term, this 20% threshold is met. But in the long term, if enough of these employees are rehired to bring the percentage under 20%, then the partial plan termination may not have occurred. It's a facts and circumstances test that follows IRS guidelines. Hardship withdrawals usually are made from plans that rely on an IRS safe harbor provision. The final regulations for hardship withdrawals permit plans to issue hardship withdrawals under a federally declared disaster standard. But please note, not all plans have adopted this standard. Also, while FEMA has declared coronavirus a major disaster to all states and territories, at this time, its website states no assistance is available to individuals and families affected by the coronavirus. Crisis counseling is listed as individual assistance in their individual assistance program and policy guide and is available in the declarations for at least 10 states. But this assistance appears to be block grants to states to provide such services locally and not directly to individuals. Therefore, we advise not issuing hardship withdrawals on account of COVID-19. However, another basis for hardship might apply: to prevent foreclosure, for medical care and expenses, and to pay tuition, among others. Many plans provide other withdrawal types as well. Upon attaining age 59 and a half, rollover accounts are generally available, and employer contributions sometimes are available under certain designs, such as after the contributions have been in the plan 2 years or after a participant has been a participant for 5 years. Also note that plans can be amended to add or modify in-service withdrawal types, subject to certain conditions and restrictions. In-service distributions may be subject to federal income taxes and a 10% early distribution penalty tax. So expanding the range of withdrawals might make the money available to participants, but they will have to pay taxes on those amounts. Which brings us to the CARES Act. One of the provisions of the CARES Act provisions allows coronavirus distributions to be taken from an employee benefit plan during calendar year 2020 by a qualified individual. A qualified individual is someone, a participant, an individual who's diagnosed with COVID-19 or whose spouse or dependent is diagnosed with COVID-19, who experiences adverse financial consequences as a result of being quarantined, furloughed, laid off, having reduced hours due to COVID-19, COVID-19 child care issues, or who has closed or reduced hours in a business, or other factors that the Secretary of Treasury may determine. There's no due diligence required to determine whether or not somebody is a qualified individual. The administrator of the plan can rely on the individual's certification that they fall under one of those categories. Also note, there's no requirement to show need, which means that people can take the money from their plan accounts and use it to pay for housing or medical expenses or other necessary items, or they can use it to buy a new car, buy a condo, or other purposes. Another item to note, plans are not required to allow for coronavirus distributions. It's optional. So if a plan does not provide for in-service distributions, it does not have to add them. If a plan offers in-service withdrawals, it does not have to expand them. Even if a plan does not add coronavirus distributions, a qualified individual who receives a distribution under a plan's existing provisions, as in-service withdrawals or termination distributions, can still take advantage of the CARES Act tax-favored treatment of the distribution. So we recommend that in this case, if a plan does not provide for coronavirus distributions, plan sponsors should still inform participants of the favorable tax treatment and ability to repay those distributions. If the participant takes the money into income, they can avoid the 10% early distribution tax. Distributions are limited to $100,000, and that early distribution penalty tax applies to an in-service payment to somebody who's not yet age 59 and a half or who terminates employment before age 55. The amount that's distributed under a coronavirus distribution can be recontributed to that plan or another plan within 3 years after the date of the distribution. And if the individual does not recontribute the amount, the distribution can be taxed over a 3-year period. Also note that because this is an optional provision, a plan sponsor can elect lower amounts. For example, you could limit the distribution to $50,000 or $25,000. You can restrict the accounts from which a participant can take the withdrawal, and you can specify the permitted number of withdrawals that can be taken. So the flexibility of these options depends on the record keeper's systems. Also, participants can be encouraged to consider how much they really want to withdraw. This is money that's intended for retirement, and while immediate short-term needs might be satisfied only by taking a distribution like this, participants will sacrifice the retirement income and be responsible for paying taxes. An employer can decide to add a coronavirus distribution anytime during 2020. There's no need to do so immediately. The employer might want to look at the employee demand, the actual state of their business. The East Coast and West Coast have been hit harder by the coronavirus than some of the other states. And other factors should be considered when deciding whether to make coronavirus distributions available and whether any limitations should apply to that. So let's move on to loans now. Existing loan provisions may be problematic for participants on a suspension. Plans can allow participants to continue to make repayments from their personal accounts as long as the plan and the loan policy permit that, and the trustee will accept direct checks or electronic transfers, and the participant has the money to make those repayments. Participants who are on a leave of absence may be able to forego making their loan repayments without triggering taxation of the loan, as long as the unpaid leave does not exceed 1 year and the participant repays the loan by the end of the original term by making up the missed repayments, either through a lump sum when they return to work, making a lump sum at the end of the term of the loan, or increasing the amounts of each repayment during the remainder of the repayment period. But the loan policy must provide for such suspensions. If participants are already making repayments from their personal accounts, the plan administrator can confirm whether the plan's loan policy permits suspension of repayments and notify those affected participants accordingly. A few additional items to note. If a participant's loan repayments end while on a leave, the loan policy will include a cure period to make up the missed repayments. If the repayments are not made up, the loan will be a taxable deemed distribution. If the participant's employment terminates, the loan policy will require repayment of the entire balance within a certain period. And if repayment is not made, the loan will be a taxable planned loan offset, or if the participant takes a distribution in actual taxable event. In each case, the penalty tax of 10% will apply unless the participant has attained age 59, or if they're terminated, they're at least age 55 or older. The participant can roll over the loan amount any time before his tax return due date for the year the loan becomes taxable. So if a loan becomes taxable in 2020, they have until April 15th, 2021 to institute a rollover of the amount that was deemed distributed or treated as a plan loan offset. With respect to issuing loans, participants don't always recognize their negative implications when they take a loan. There are initial fees and typically annual fees to maintain a loan. Once they've taken money out of their account, they miss growth on their tax-deferred earnings. If they take a loan now, they're selling investments toward the lower end of the market. Repayments are made from after-tax amounts, and if they miss repayments or default, they may be liable for taxes. The CARES Act also made changes to the loan rules to make them more flexible. The loan limit is increased from 50% of a participant's vested account balance up to $50,000 to 100% of the vested account balance up to $100,000 for loans from qualified plans to qualified individuals made during the 180-day period from the date of enactment. So while coronavirus distributions are available for calendar year 2020, CARES Act loans are available between March 27th, 2020 and September 23rd, 2020. Like coronavirus distributions, the CARES Act loan changes are optional. A plan that does not provide for loans does not have to add them, and a plan that does provide for loans does not have to change them. There are other options. Coronavirus loans can be added as a feature only while the CARES Act applies. A plan that provides for loans can retain its existing limit on the number of loans or expand the number of loans for additional CARES Act loans. Coronavirus loans also can be made available on a modified basis, such as 100% of the account, but only up to $50,000. Could limit the amounts available to specified accounts or for specified reasons. Some plans allow loans based on the same reasons that hardship withdrawals can be issued. The options depend primarily on the record keeper systems, which aren't always as flexible as they are for the distribution options. An important item to note, though, is that coronavirus loans can be made up to $100,000. But the debt burden on such a loan at 5% is $872 per biweekly paycheck, which is over $22,000 a year, which is out of reach for many participants. Also, loan suspensions. They also are possible under the CARES Act as an optional provision. This allows the due date for a repayment by a qualified individual that would occur from the date of the CARES Act enactment on March 27th through December 31 to be delayed for up to 1 year. The later repayments for the loan are adjusted to reflect the delayed due date to account for the interest that accrues during the delay. And that delay period is ignored when you determine the 5-year maximum period, which means that if you delay your repayments for 6 months, starting July 1 through December 31, the original loan term is extended 6 months as well. Note that The participant does have to make up the accrued interest, which means the repayments are recalculated when they resume. This can be difficult for many administrators and record keepers. It adds a lot of complication to loan processing. Also note that if repayments are missed before the March 27th effective date, they cannot be extended under this option and have to be made up by the end of the cure period, or else a deemed distribution will occur. If a participant terminates employment, the plan's regular loan policy on termination of employment will apply, and as previously discussed, the outstanding balance must be repaid by the deadline stated in the loan policy, or else the amount becomes a plan loan offset. Of course, the CARES Act then adds a wrinkle. If a participant is a qualified individual who has not already taken coronavirus distributions of $100,000, he or she should be able to treat part or all of that taxable event as a coronavirus distribution and take advantage of the favorable tax treatment, longer rollover period, and avoidance of the penalty tax. An employer can, if it wants, amend its plan document or loan policy to add flexibility to its loan program within limits, such as allowing additional loans or additional money types that might otherwise be restricted. So back to our general operational discussion. It's important to note some of the side effects if participants reduce their deferrals. There may be an impact on non-discrimination testing. If non-highly compensated employees suspend their deferrals and do not receive matching contributions, the plan's non-discrimination tests might not pass at the end of the year. If this is a concern, employers should monitor the HCE's behavior and impose limits or prepare them ahead of time for possible refunds once the testing has been performed. Depending on the length of a suspension, participants might miss out on employer contributions or vesting service. Many Northeast and West Coast states instituted stay-at-home orders in March, less than 3 months into the calendar year. It's unclear when employees will be able to return to work, so it's premature to speculate on what the actual effect will be on vesting service or employer contributions for a plan that has 1,000 hours of service rule for either or both. Employers may find that they want to change their contributions. If a plan has a discretionary formula, employers can consider suspending or deferring making those contributions if they're made on a periodic basis, which generally matching contributions and some profit-sharing designs provide for. If discretionary contributions are made at the end of the plan year, there's time to see what happens. If a plan has a predetermined formula, a fixed or mandatory contribution, the employer can consider amending the contribution provisions to make them discretionary or to simply suspend them. There's a few cautionary comments. You cannot take away contributions that have already been allocated to participant accounts or that have to be allocated to participants. You can only change these prospectively. Thus, if a plan does not impose any requirements on receiving contributions other than salary deferrals to receive a match, the participant is entitled to those contributions until the plan is amended to change them. Also note, for plans with different contributions for different groups of employees, such as different divisions or companies within a control group, changing the contribution for one or more of those groups may require additional non-discrimination testing. Safe harbor designs are more complicated. Safe harbor designs require contributions to be made to accounts based on participants' compensation as a safe harbor QNEC or based on salary deferrals as a match or a QACA. Plans can be amended during a plan year to suspend or reduce safe harbor contributions if the annual notice provided that those contributions could be suspended, or if the company is facing financial hardship, which generally means operating at an economic loss. To suspend contributions, a notice must be distributed notifying participants of the suspension at least 30 days before that suspension takes effect. The Secure Act eliminated the annual notice requirement for safe harbor QNEC plans, which means there was no reservation of rights to suspend because there was no annual notice. But we believe best practices dictates that the supplemental notice can be distributed. The plan then has to be amended before the effective date of the suspension to make that suspension effective, and the plan has to have provisions for the ADP and ACP tests, if applicable, and the employer has to pay the safe harbor contributions through the date of the suspension. Also, and this one is important, the plan will not be able to rely on the top-heavy exemption available to safe harbor plans, which means a top-heavy plan might still be required to provide top-heavy minimum contributions to non-key employees. And the cost of the top-heavy contributions potentially could exceed the cost of the safe harbor contributions. Also, if a plan does not follow the proper steps to suspend safe harbor contributions, the IRS could determine that it's no longer tax qualified status holds. The CARES Act suspended required minimum distributions that are payable in 2020 from defined contribution plans. This applies to both initial distributions for 2019 that were payable by April 1st and the distributions for 2020 generally that are payable before the end of the year. Participants who received their 2019 initial required minimum distributions should be informed they may be able to roll over those payments. If they're qualified individuals under the CARES Act, those payments also might qualify as coronavirus-related distributions for the favorable tax treatment. There are other possibilities through congressional action and agency action. The IRS and Department of Labor have authority and have previously declared emergencies that permit greater latitude for hardship withdrawals and making larger amounts available for loans, which may help participants who are not qualified individuals under the CARES Act. As of now, the IRS and DOL have not provided such guidance. If an employer does change its operations, it will be required to adopt a plan amendment to reflect those changes. Thus, if the plan provisions are modified, such as loans or in-service withdrawals, that amendment has to be executed by the last day of the plan year. If there are changes that involve suspending contributions, as previously explained, that amendment might be required sooner. In some cases, the timing to adopt amendments may be extended. For example, the deadline to adopt amendments for the CARES Act changes will be the last day of the first plan year beginning on or after January 1, 2022, which means for calendar year plans, the deadline is December 31st, 2020. The Treasury Department, IRS, and Labor Department have authority to extend deadlines for required administrative filings, and in fact, they have done so. The Form 5500 deadline has been extended for plans with deadlines falling on or after April 1, 2020, and July 14th, 2020, until July 15th, 2020. This means calendar year plans do not have an automatic extension, and the current July 31, 2020 deadline still applies for the 2019 Form 5500 filings until further notice. The agencies also could extend the deadline for distributing excess deferrals for correcting failed ADP or ACP tests without incurring the 10% penalty for distributions after the statutory deadline. The DOL and IRS recently provided relief for certain notices and disclosures that are required to be provided under Title I of ERISA. EBSA's Disaster Relief Notice 2020-1 provides that a plan and the responsible fiduciary will not be in violation of ERISA for failing to timely furnish a notice, disclosure, or document required between March 21st, 2020 and 60 days after the end of the COVID-19 national emergency, if they act in good faith and furnish the required item as soon as reasonably practicable under the circumstances. And the DOL specifically noted that good faith acts include the use of electronic alternative means of communication. The DOL also provided limited relief with respect to verification procedures for loans, delayed participant contribution and loan repayment deposits, and distribution of blackout notices. We expect that the agencies will continue to issue guidance like this that will make it easier for employers to comply with the rules under the current state of affairs. Another administrative issue that employers and plan sponsors have to deal with is the performance of the investments recently. Most defined contribution plans these days are participant directed. While investment advisors generally suggest staying the course, many participants panic. Given the huge amount of accounts invested in the plan's default investment option, this might not be as significant an issue as it was in the past. Also note that while the market dropped 20 to 25%, it's already come back significantly, and the net effect on participant accounts might be in the 5 to 15% range of a decrease, which means that money they're putting into the plan now is buying at a lower price, and it can be expected to increase over time. Sponsors and their service providers should provide information and guidance to participants to make sure that they can use tools to avoid emotional responses and allow them instead to make informed decisions for their retirement money. Some plans still have trustee-directed investments, and when trustees direct investments, they assume the fiduciary risk of their choices. This risk can be passed on to participants by satisfying investment option requirements under ERISA, Section 404C, by offering at least 3 diversified investment options, reallocation of accounts at least every 3 months, and providing the information about the investments so participants can make informed choices for themselves. So that raises the question, what should plan administrators do? And from an administrative standpoint, they should ask the investment advisors to review the plan's assets to determine whether the 401k plan or other investment lineups or pooled accounts still serve the needs. By reviewing the short and long-term risks, review the plan's investment policy statement to make sure it's still reasonable, examine investment valuations and the impact of the economic investment on the performance. It's also important to examine the liquidity needs of the plan. Is there a lack of market liquidity in the investments? Are there investor redemption options that are limited? Typically, you don't see those in an individually designed, in a participant-directed plan, more so in a trustee-directed plan, but there are considerations nonetheless. The administrator also wants to confirm there are no advisor conflicts. Do they handle proprietary products? Are there any affiliated investment advisors? Review any new advisor disclosures or information carefully. Consider share class and fees. and update any 404C information, that's the participant direction of investments, about those investment options so that participants can make informed decisions. So these are some of the operational and administrative considerations. And I'm going to turn over the rest of the presentation to Steve, who will discuss the fiduciary considerations involved with the investments and the administration of a plan.
Thank you, John. I think those operational and administrative considerations are so important right now because they're incredibly complex. There are a lot of technical requirements in the law around them, and they've been subject to various changes under the Secure Act and CARES Act over the last couple of months. It's a lot to keep up with, and it's very important that people focus on it. And I think really that's what the main thrust of our webinar is today. So let me finish off our discussion with some issues through a fiduciary prism, just to put a little gloss or a little additional perspective on it. I'll start out just with just a couple of general thoughts. One of which is to say that, during times like this, economic volatility or, even, a bankruptcy situation for a plan sponsor, ERISA has no, specific provisions or guides or, separate set of standards that govern the conduct of a fiduciary during these tough times. I think all these fiduciary activities are subject to heightened scrutiny, even more second guessing than ever by people from the rearview mirror. But the rules of the standards and the rules are effectively the same. So a fiduciary's responsibility to protect the integrity of plan assets, to collect contributions from the plan sponsor, to protect employee contributions, deal with distributions, monitor the filings, look after the investment decisions, all those different areas of fiduciary responsibility. The standards remain the same. A fiduciary is just facing, tougher challenges and tougher navigation. I think that one of the things to think about during this time, John and I have in our firm, we've been through various cycles of economic volatility, going way back to the debt crisis, the junk bond crisis in the mid '80s, 9/11, recessions, what have you. So there are a couple of issues that come out that we've seen that tend to, repeat themselves. So I want to call those out for you today so you can be aware of them and we can highlight them a little bit. And one of those is just the reminder that oftentimes the fiduciaries of your plans will be wearing two hats. It's okay to be a fiduciary in some capacity and a non-fiduciary in another capacity with regard to your corporate, your job responsibilities, the plan and what have you. It's not a violation per se, but clearly it creates a conflict that has to be very carefully monitored. So situations about, amending benefits, suspending matches of the 401k purposes, terminate a plan, freeze a plan, all those kind of things. Some of them are set law functions. They're kind of in the realm of corporate employer decision making, and there are other areas of decision making that fall under the fiduciary roof, and you need to be very mindful of when you're wearing, which hat. I would also remind people that the statute, ERISA, imposes personal liability on fiduciaries. So to the extent, when the owner of your business or officers are involved in a fiduciary capacity with regard to the plan, remember that there's personal liability for fiduciary breaches. You have to repay losses to the plan, restore lost profits. It's a very high standard of conduct, and you're on the hook for personal liability, and that's something we wanted to remind you of. Finally, I would also say just one of the things to be on the lookout for, another thing to be on the lookout for is the distinction on, in our DC world, sometimes the analysis and the protocols with regard to employee contributions, like in a 401k, they go through a different filter than employer contributions. I mean, the DOL generally, says employer contributions, they become a plan asset, once the contribution is actually made. Maybe the right to receive the contribution is an asset, but the plan documents, might have something to say about that as well. And there's been some DOL advisory, opinions on it. But employee money, when it goes, is a plan asset. It's important to think about distinguishing those two sources. In terms of, John mentioned 404C a little bit before. I just want to add a little more to that. I think right now is a very important time for fiduciaries to be focused on 404C protection to the extent you have it. I mean, ERISA imposes personal liability on fiduciaries, like we said. But a plan, where a plan has individual accounts, like, a 401k, and participants, exercise their own control over their investments, the fiduciaries won't be liable, for any losses that result from a participant's investment instructions, where the participant really controls the plan, if it meets the requirements in ERISA Section 404C and the regs. And I think the regulations, if you actually go through the regulation, I think you have to, I can't remember the exact number off the top of my head. I think it's about 24, 25 boxes you have to check. John alluded to them before. But I think this is a very important time just to be from a fiduciary governance point of view with regard to your plans, and to make sure people understand where responsibility lies and where, responsibility, should be allocated. 404C can be a little tricky. I think a lot of times plans think they're in compliance with 404C and they're not. This is a good time to kind of maybe check that. One thing for sure, we know that you have to have, a participant has to have a reasonable opportunity to, affect the returns and control the risk of the investment in his account. The plan must offer at least 3 investment alternatives that are diversified, that have materially different risk and return characteristics, and that enable a participant to achieve a portfolio with the right kind of risk and return characteristics, within the range that's appropriate for that participant. So I guess what I'm saying is this is a great time to, to check with your investment advisors on many aspects of your plan, including 404C. How do those investment options look right now in the short term? I know that neither John nor I are pretending to be investment professionals nor giving you investment advice. We're simply saying that these are good questions to ask, given the volatility in the market, the nature and characteristics of some of these funds vis-a-vis their relationship to other funds in that menu might have shifted, and there might be some rebalancing that's in order. So it's a good time to really check on 404C compliance, also see how it matches up with your investment policy statement, and the kind of disclosures that you've given to your participants. So 404C requires some attention. I would say also the same thing. It's a good routine question right now just to ask about QDIA investment, to see if you still feel it's the right one for your employee demographic and for your employee population. A high-tech company in California with an average age of 28 or 30, 35, younger employee base, versus a more mature, manufacturing base in Chicago or in the Northeast, where the average age of the employees might be higher, just suggests that that middle of the road, that qualified default investment alternative could be different in each of those plans. And what maybe one size for all with balanced funds worked a while ago, maybe during these current times, the fit isn't quite as comfortable. So these are things that you just want to review. I think other things that you want to do generally at the moment with regard to your overall plan investments, as John alluded to, from an administrative point of view, but also as a fiduciary. An administrator can be a fiduciary, but so is the investment professional on a plan. As the investment professional on a plan, you want to be looking at, really reviewing the performance of your funds. Maybe call a special meeting to show that you're addressing these volatile times, rather than wait for your next quarterly meeting to roll around, which is not until August or whatever. Really look at the funds, see what your asset allocation looks like, and see style drift and things like that, performance against peers and benchmarks. You always want to be sensitive to proprietary funds and affiliated funds and share class. These are all issues that you should be thinking about anyway. as I mentioned before, they're heightened now because of the times we're in. See if anything, needs to be replaced. Maybe some of the managed funds are a little bit expensive. They could be replaced with low-cost index funds. These are all things that your investment professionals will coordinate with you. But I think they're good questions to ask. You want to be checking on fees, revenue sharing offsets, all those kind of things. And even your investment advisor, itself or himself or herself, as is the case with all your vendors, be clear that they've acknowledged their fiduciary status and that, the management team is intact and they seem to, have the experience and knowledge to get through these particularly rough times. With smooth sailing, it's an easier job. When the sailing gets tough, it's a time when experience and some other skills really become more valuable. So these are good questions to be asking at the moment. I think that documentation, as it says here on the slide, documentation is really, really key for everything: administrative, operational, fiduciary, investment. It's so important. We live in an era of transparency, and all the leanings of the DOL and the SEC and all the regulatory bodies with regard to their respective areas of jurisdiction say that one of the ways to demonstrate that you're doing the right thing and making a good effort is to keep good records. So documentation is really, really important. And as John mentioned before, and I'll talk about it again a little bit, this is also a good time on your 401k plans to, to educate, to work with your participants. Now, that there is no duty to provide education. There's no duty to provide advice to participants. But I think that it's become a standard for people to abide by and a best practice. So you want to be thinking about the information and tools that your participants have, like John said, to make sure they understand, how to keep a cool head when, how to evaluate these investments, make sure that they have the right perspective to go through these tough times. I think that as part of that, next slide, please. I think as part of that on employee communications becomes especially important. It's not just the tools that you give them, but it's the messaging. It's the messaging that you are giving to. It's the messaging that you're giving to the employees. We learned a long time ago from the Supreme Court in the Verity case that sometimes when you might not think you're a fiduciary at the moment, but you are when your employees are in the room and they're asking you questions about the plan, and you're in that kind of management plan leader role, your fiduciary hat is on. And it's really important that you communicate accurately, that you don't necessarily hold back to answer only questions that are asked of you, but that you take the lead to provide information even to the unasked questions, and that you really avoid, slick answers and, misrepresentations or, tricky, very nuanced disclosures. I mean, obviously the messages are all nuanced to the extent that we're giving them thought, and you have to be careful. But employee communication from a fiduciary point of view is always important, and is really going to be super important right now, during these times when people are going to be asking a lot of questions. And as I mentioned before, just a review of your QDIA is also really important. Now, some participants might check out. They might not they might not know what to do and just literally check out. And your QDIA should be the right QDIA for them to address the situation we're in. Next slide, please. So we know one of the biggest issues that we're going to face in our experience during these times are employer stock. We have it as a match in a lot of our 401ks. It's an investment option in a lot of our 401ks. It could be a discretionary contribution with on top of the 401k aspect of a plan. And whether you're a publicly held company or a private company, whether it's just an investment option on the menu or you're more of a structured ESOP with significant percentages as compared to being a stock bonus plan, it's a really, really important time to understand what role that employer stock plays in your plan, how it's being addressed, what action, if any, needs to be taken, who the decision makers are. Now, in a closely held company, you know, there's no market. So valuation is always a challenge. It's a little, you know, there's always, some subjectivity, part art, part science, you know, relying on valuation experts and so on. But right now, I think, you know, it's the valuation challenges on closely held stock are really, really pressing, and you need to have a process and an ability to address that. You need to, you know, to be asking, you know, your counsel or other people, how are we handling the valuation issues? You might have put options that are coming into play on an ESOP, or in diversification requirements where people need to kind of need to cash out. So it's really important that you have a handle on your on the valuations of your closely held stock, to the extent that it goes on the balance sheet, to the extent it's on your 5500 or on your financials. Who is signing off on those statements? Who's the decision maker? Is that something that your accountant or valuation firm is signing off on? Does the trustee not own that valuation responsibility? So you have to understand the implications of the difficulty of the valuation and have some processes in place right now. That's something we've learned from the past, and it's clearly going to be present. With regard to public company, you know, for public company stock, where people maintain stock as an option in their 401k plan, and they either hold direct share accounting or maybe it's a unitized fund, it becomes the same thing. That you know if you believe in free market and efficient market, you know the value every day, and I think that one can, to some extent, can rely on the valuation of the daily close of the markets in our marketplace. But the decision making and the volatility around that stock suggests that a lot of decisions are going to have to be made right now. Do we continue to offer it as an option, given the volatility? Do we just freeze it for a while? Do we terminate it? Do we just freeze our unitized stock fund right now? And do we sunset it and permanently, you know, move it out? There was a lot of stock drop litigation over the years, and I imagine it unfortunately might come back again now because of the way the market is moving. I do think that I want to talk just for a minute about the court cases, because at least I think we're getting some help from the courts. One of the biggest challenges on public stock has always been the tension between, I talked about, you know, settlor, you know, two-hat capacity before for people. If you're at a public company and you're an insider and you're in the treasury, you know, in the Treasury Department or the financial office or whatever, or just in a C-suite, you might have certain information about, you know, which is not public because of the securities laws, but there's certain things you know about the company. We're going to sell a subsidiary. We're going to buy a new one. We're going to suspend this. You know, all those activities that might influence the value of the stock, but the securities law would prohibit you from disclosing that. But if you're also wearing a fiduciary hat because you're on the plan committee, or just, you know, the company itself is the named fiduciary, and therefore, you know, as an officer of the company, you kind of represent the company. You know, you get a real tension. Back in January of this year, the Supreme Court issued a decision in a case called IBM versus Jander. It was a very closely watched case, and it regarded kind of the pleading standard for stock drop and disclosure claims under ERISA. And the court kicked the decision back down and remanded for further proceedings, and otherwise to decline to address the merits of the case. So they left some open questions for us. We were hoping they were going to resolve a circuit split on the very famous Fifth Third Bancorp v. Dudenhofer case, but they didn't. In that case, the Supreme Court held that to state a claim for breach of duty of prudence under ERISA on the basis of a failure to act on inside information, a complaint would have to plausibly show an alternative action that the plan sponsor or the defendant could have taken that would have been consistent with the securities laws, and that a prudent fiduciary, you know, in the same situation, would not have viewed as more likely to harm the fund than to help it. And there have been circuit court splits on whether you state a viable case and what the standards are and how to deal with information. I won't go into all the information, into all of it here right now, other than to say that the old Dudenhofer standard is still in place, and that puts a heavy burden on the plaintiffs pleading. You know, they have to properly plead this duty of prudence claim, and it didn't really change existing law, but it leaves some questions open about when you're required to act on the basis of inside information or not. So these are kind of tough issues. Do you have inside information or not? Where do the securities laws play? What role do you play? Are you a settlor or not a settlor? Are you a fiduciary to the plan? Very oftentimes, firms will turn to the retention of an independent fiduciary just to navigate the employer securities issues. Our firm has been involved in that scenario before as the independent fiduciary. So that's just something we want you to be heads up on with regard to employer securities. Valuation issues are very tough. It's very volatile, closely held situation. You have to answer employer puts and what have you. Be aware of those. And in the public company scenario, we're waiting for further guidance from the courts, but there's some real tensions between ERISA and the securities law that are yet to be fully resolved. Slide, please. I think that John talked about plan administration before. Obviously, especially now with everyone working remotely, administration is one of the three prongs of fiduciary duty. We have investment advice for a fee. That can make one a fiduciary. Investment management, if you will, of plan assets, discretion over assets, that will make you a fiduciary. And just the administration of a plan, administering the terms of a plan, the operational plan, that is the important decision making, that's fiduciary as well. And it's very important that during these times the plans continue to roll, with everyone working remotely. There's nothing in the ERISA statute that says during a time like this, if people have to work remotely, the standards are lowered. So it's really, I think it's good that everyone take a look at kind of how are things going for our committees and our board. Are we able to sign things? Do we have, e-signing capabilities and laws that are passed that honor e-signatures? We have notary statutes that can be done. We have notarization electronically now. The states have been passing legislation over the last couple of weeks to allow for that, in terms of signature authority. So all the underlying, systems and procedures and methodologies that are used just to keep the train rolling, to make sure that they're leaving the station on time. All these administrative matters, need to be well lubricated and requires your attention. I want to point out one thing. Let me talk about another Supreme Court case, which is topical, and I think it relates very heavily to just administration generally and to the effectiveness of disclosures that you might make as part of your administration. A couple of months ago, the Supreme Court had a case with Intel, this one, the chip company in Silicon Valley, Intel Investment Committee, and they've been dealing with a variety of issues in that case for a number of years. But the issue I'm talking about refers to when does a party have actual knowledge? In other words, if you make a disclosure to a participant, in terms of measuring the ticking of the clock on the statute of limitations and just the overall effectiveness of your disclosure, how do you know? How do you prove? When do you turn the switch on? On what day can you say that participant had actual knowledge? It becomes an important concept. And in Intel, a plaintiff, either failed to read or couldn't remember reading disclosures, and the defendant came back and said, well, we sent them emails, we made all these electronic disclosures. And the Supreme Court ended up saying that, you need actual knowledge, to trigger, the statute of limitations. And it requires more than evidence that a disclosure was made. The Supreme Court said that actual knowledge means that the plaintiff must in fact have become aware of the information, and that a plaintiff doesn't have actual knowledge if they receive something, if he or she receives something but doesn't read it or doesn't remember it, or maybe even doesn't understand it. I mean, a lot of that is really unknown. So actual knowledge and real knowledge are things that we're still going to be working on, and the case is going to require some more support. But in the meantime, this is very important for plan administrators on a fiduciary basis, especially in the electronic world we live in. What can you do to make sure, number one, for the noble goal of making sure that your participants receive and really understand the information you're giving them, and number two, to the extent that you want to demonstrate compliance with deadlines for making disclosures or, sharing information, you want to show that you effectively did it. What can you do in the meantime? We have a pretty good client alert on our website that you can take a look at. But some of the suggestions that we've been making to our clients are to, hold a meeting, have everyone log in and attend a meeting and acknowledge and check the box that they heard your 30-second explanation. Or maybe you can post a little 1-minute, video online that you require all your employees to look at to make sure they understand the disclosure that was made. And if it was overly complicated, maybe you can, put out a summary of the disclosure just to help them, ease the digestion of the technical terms and refer them to to the technical disclosure itself. But at least you've given them a summary. Again, pre-recorded explanations, and sending it via email. There's software available. You can get. It's pretty easy to see when you can timestamp when someone has received an email, when they've actually opened it, maybe when they've opened the attachment. You can timestamp those kind of things with a lot of software tools nowadays to prove that you've made the distribution. So those are some of the practical things that you really want to think about. Just sending someone an email and assuming that everything is okay might not be good enough. You might want to tighten up. We think you should tighten up on that a little bit. Now, by the way, the DOL, has their own, they favor electronic communication as an effective means of disclosure. And they have, the regulations are being reviewed right now by OMB. So hopefully there'll be some more guidance shortly from the DOL. But we know that the department, from their own point of view, are very much in support of and favor reliance on technology as a means of distributing disclosures and providing other important information. So, slide, please. Final point here is, as John mentioned before, and I'll say again, all the service providers, not just your investment advisors, but hey, your accountants, your record keepers, your actuaries, your consultants, attorneys, whoever it is, you want to make sure it's a fiduciary responsibility to appoint those people when you're spending planned dollars typically to retain them and pay them. It's a fiduciary responsibility to not only appoint them, but to monitor what they're doing for you. So as a general proposition, it's really important to keep track of your service providers and make sure that they're staying on course for you and on target. This is a good time to kind of review who your vendors and providers are. Just ask yourself, is everything up to speed, or are agreements in place? Are they doing what we need them to do? Do they have the expertise to navigate us through this particularly rough time? Do the fees and services look appropriate for what we're getting? Things like that. And you want to be able to demonstrate and document that you asked the question, because for all these fiduciary issues, necessarily getting a perfect outcome, that's not ultimately or necessarily the final test. The real test is, did you ask the right questions? Did you try to get the right answers? Did you try to get the right result? In other words, what was your process like? Did you act like a fiduciary? And internally, with regard to we know that your HR departments are getting a lot of questions right now from participants. We think that you should be very careful to advise your HR departments and make sure they're fully informed on the complete aspects of the plan, the operations, plan investments, plan information, plan data. You want to make sure that they're trained. Everyone in the HR department that's fielding these questions is properly trained and knowledgeable about the kind of questions they're getting. And presumably, you want them to stay within the contours of what we would call education rather than giving investment advice. Now, with the fiduciary regulation having been vacated, we're back to the old interpretive bulletin 96-1. We think, we're pretty sure that's the law again. 96-1, which defines the distinctions between education and advice. And I mean, clearly, investment education, you can talk about, what's on the plan menu and information about the menu, general, investment concepts, like just the power of compounding, saving for the future, how that works. Maybe some things about asset strategies or asset allocation, some sort of decision making around that. But clearly, you do not want to be in the investment advice business in the HR department, which means you're not making, even though it's tempting to help your friends out and your fellow employees, we don't think that you want to have the responsibility to, be advising participants on which of the three mutual funds in the, large cap equity sector they should choose, or why they should move to small cap from large cap, so on and so forth. So no specific recommendations, of course, just general information and providing them with the tools, as we say. Slide, please. I think the final point we're going to make here, I'll do it quickly, is we've been talking about fiduciary responsibility and fiduciary processes and decision making. This is a very good time to reassess and reconfirm who are the fiduciaries. Every plan will have a named fiduciary or a process by which a named fiduciary is determined. Plans by definition require a trustee, and there can be many other fiduciaries involved. You could have one or more investment advisors, third-party administrators, consultants might take a fiduciary role. The plan administrator role might be outsourced to a third party, or it could be the employer. I think at this time right now, it's really very important to understand fiduciary governance, who the fiduciaries are, how that decision-making is allocated to make sure it doesn't improperly overlap and that there are no gaps. You want to be mindful of the functional or inadvertent fiduciary, because notwithstanding the nomenclature of someone's business card or an agreement, at the end of the day, fiduciary status is not determined by title or a paragraph of a contract. It's going to be determined by functionality. What did he or she or it actually do? If someone assumes or exercises a fiduciary role, they will be a fiduciary. They'll be deemed to be a fiduciary to the extent that they undertook that role. So it's a good time to take stock of yourself in that regard, to make sure you have the right governance in place, make sure you have the right ERISA bonding in place, which is required under the statute, and on an optional basis, even though it's not required, just to look at your fiduciary insurance policy and make sure the right people are covered. We recently found a situation where a fiduciary policy named, John Smith as a fiduciary for a plan rather than the treasurer of the company. Well, John Smith retired and was replaced by, Joe Brown, and Joe was not named, so we were able to make that correction. Seems pretty simple, but little things like that happen. So it's a good time to review and assess your fiduciary insurance. And with that, John, I'll turn it back to you.
Thanks, Steve. We don't know what the long-term prospects are for the economy. Clearly, there's a lot of issues we couldn't possibly cover in just an hour or so. So we did want to give an overview about the effect of this current economic effect on defined contribution plans and their participants. But until we start moving forward and get through this, it's hard to tell at this point what the prospects are for these plans going forward. But we hope we can provide you this information that you can take it and use it and improve the operations and administration of your plan and understand your responsibilities as fiduciaries of a plan.
So I guess with that, thank you, John. It's always a pleasure to be with you on these. I always learn a lot when I hear you speaking, so thank you very much. And on behalf of the Wagner Law Group, everyone please stay healthy and safe. We wish you all the best. If you have any questions, please let us know, and we'll look forward to talking to you soon. Thank you so much.